Imagine a sitting executive announcing that alongside the written constitution, there exists a second, equally binding, unwritten oral constitution, a corpus of laws known only to a few, yet carrying the full weight of the state. The outrage would be immediate. We understand instinctively that a constitution does not permit parallel, unwritten authorities to simply materialize. If an authority is not created by the charter, it does not exist. The debate over the oral Torah is often framed as a matter of religious tradition, but strip away the theology, and the controversy is a strict matter of constitutional law. Every legal proceeding must first identify its governing instrument. In this dispute, both sides agree on the foundational rule. The written Torah is the supreme, deposited constitutional record for the covenant. This agreement activates the Master Theorem of constitutional law. A constitution cannot generate authorities that exist outside of its own framework. To be valid, an office or a law must be admitted through the procedures the Constitution itself establishes. The oral Torah makes a precise claim that an unwritten corpus was given at Sinai with authority equal to the written text. This isn't a claim about interpretation, it is a claim about the existence of an additional source of law. Because the oral Torah claims constitutional status, it must be subjected to a trial using the admission rules defined by the written Torah itself. Legal status is not a matter of popularity. Just as a passport identifies citizenship rather than creating it, constitutional identity is defined by strict criteria. If a claim does not meet the criteria, it cannot be admitted into that class. The governing instrument requires 5 properties to be admitted as Sinaitic: public revelation, prophetic authentication, written deposit, legislative closure, and content authentication. These form a single, indivisible constitutional class. For a law to be legally identifiable as Sinaitic, it must possess all 5 simultaneously. Any authority claiming the rank of Sinai must match this structural blueprint. If even one property is missing, the claim belongs to a different class of authority entirely. This creates a binary fork. In the eyes of the law, the oral Torah is either Sinaitic revelation or it is human jurisprudence. There is no third category. If we test the first horn, the claim fails immediately. The oral Torah's unwritten format and private transmission through a chain of teachers directly contradict the requirements of a public, written, and nationally witnessed deposit. If we move to the second horn and assume the oral Torah is instead a form of human jurisprudence, judicial interpretation derived from the court mentioned in Deuteronomy 17, the claim finds a valid office. But here, the doctrine encounters a jurisdictional trap. A court can interpret existing law, but it cannot create new divine revelation. Derivative authority flows strictly downward. It can never ascend to the level of the legislative event that created it. This is the principle of constitutional estoppel. A party cannot draw its authority from a constitution while simultaneously claiming to be exempt from that constitution's rules of admission. The oral Torah is legally boxed in. It either fails the identity test for divine revelation, or it accepts a human status and forfeits its claim to divine authority. The formal verdict is dictated by the structure of the charter. Because the oral Torah claimed the absolute highest authority, the level of Sinai, it triggered the absolute highest evidentiary burden. The very strength of its claim is what guaranteed its failure. The profound irony is that the written text the oral Torah appeals to for its power is the exact instrument that legally convicts it. The ruling establishes a permanent reality. The legislative door closed at Sinai. The authority belongs to the event, and since the event cannot be repeated, the authority cannot be transferred or enlarged. This closure is reinforced by Deuteronomy 32, a pre-filed indictment entered into the record before the nation even crossed the Jordan. It records a verdict of systemic guilt against the entire people. This creates a jurisdictional barrier. If the law places the entire nation under a standing indictment, then a court drawn from that nation is legally barred from adjudicating its own breach. In constitutional law, a party cannot sit in judgment of its own case. This architectural gap requires a single executor from outside these disqualified institutions. It requires the party who swore the original oath to step into history and fulfill the law himself. Can any institution legitimately exercise an authority that the governing instrument itself never creates?